loan application. How have you disclosed that to Mr. Tangway, and do you have any ideas to when you anticipate getting a copy?
Your Honor, we have requested it. I can't make them produce it to us. We disclosed it through a formal supplement. She did not sign it, so I'm happy to have her sign it.
And approximately when did you send that informal supplement?
Within a week of
Back
the
in
original.
November?
Correct.
Okay, just make sure to send a signed copy, if you will, please.
I will, Your Honor. Thank you.
Okay.
That's not true, and that's why we need to show that they're lying. And that's, I have evidence showing that they're lying. So I'd like to be able to get to that at
And
this
as
point.
part of a motion for reconsideration, if you wish to present that, whether in the form of affidavits or documents, you're most certainly free to do so, Mr. Tangway. Likelihood of settlement at this point in time, Attorney Ames.
Poor, Your Honor.
Mr. Tangway.
On May 1st, the Bureau of Child Support Services sent me a case summary.
And sir, what does this have to do with the likelihood of settlement, sir?
Well, because they are actually using domestic violence against me to gain.
Sir,
And this is
we're not
evidence.
talking about domestic violence right now. We talked about
We're
that
talking
earlier.
about the likelihood
It
of a
is
settlement.
lawfully.
Are we not talking about the likelihood of a
So
settlement?
is it good, very good, fair, poor? What do you think?
On November 1st,
Sir,
2022.
in one or two adjectives, how do you think the likelihood of settlement is? Is it excellent? Is it very good? Is it good? Is it fair? Is it poor?
Erica said she is hoping to
Sir,
skip mediation
pardon me, Mr.
and go
Tangway.
straight to
Sir,
trial.
I need you to answer the court's question, if you please.
No court orders as of this time.
Mr. Tangway,
An obligee will send us a copy of the orders once the orders are issued.
the court
This-
will put poor. The party
So this
shall
is from the
provide-
child
Pardon me, Mr.
enforcement
Tangway,
services.
you're not going to be interrupting the court, okay? Do you understand, sir?
I don't understand.
Okay, sir. We're having a legal proceedings that are governed by certain laws and certain rules.
What are those laws and
Okay.
rules?
They are all disclosed for you right here that we've been talking about.
They're not disclosed for me. What
Okay.
are they?
Sir,
What are the rules?
you are free to go to the law library and look up whatever rules or statutes you want.
I
The law
already have.
presumes that you are aware of such things, okay? If I'm asking you what the likelihood of settlement is, that seems like a fairly straightforward question. You were not only not answering the court's question, but you were being evasive and you were interrupting the court and ignoring the court. That is not acceptable, okay?
I apologize, Your Honor. I'm just very upset that there's no time that when am I going to be able to present this today so that we can figure out
Present what, sir?
the Department of Child Support Services has documented lying to the court on November 1st, 2022, prior to her filing a domestic violence petition. She said in writing to a person at the Department of Child Support Services that she is hoping to skip mediation and that go straight to trial. Then on November 30th.
And so what? No offense, but so what?
So what? So when I filed a motion to have the court order mediation on the 28th of November, her attorney then responded by filing a fictitious domestic violence claim with the court, and that is what has disrupted this whole proceedings. That's why we cannot proceed, and I'm
Sir,
trying to be...
Mr. Tangway,
Yes, Your Honor.
there was a finding in the domestic violence case, is that correct?
There was false mathematically...
Sir, the court's question is, was there a finding and a final order issued?
Yes, there were fraudulent statements made.
Sir, there was a finding made, is that correct?
Yes.
Okay. That's not relevant to why we're here now.
I object
Okay.
to that.
Okay, your objection is noted.
Thank you, sir.
But for the issues that we are here on today, okay, that is not what we're discussing today. If you want to make that part of your appeal, you are most certainly free to, okay?
I should not be held under duress to make appeals.
Sir,
This court is to
Sir, you
find
can make
facts.
appeals if you want. We are here for the pretrial conference, and if we actually have the time, a review hearing. I will let you know that your continuous arguments against the admonishments of the court are cutting into your time to argue the review hearing issues. If that is how you wish to spend your time, sir, you may do so.
Thank you.
Okay. With regard to trial scheduling, if we're looking at a 2-day trial, which seems to be right in the middle, right within the bounds of reasonableness, unfortunately, we'd probably be looking into early 2024. I would ask the parties to provide any unavailable dates for early 2024 to the clerk's office within 15 days. Okay, if you have reoccurring medical appointments, if you have pre-planned vacations, anything like that, just let us know. We certainly don't want to schedule the case for a day that one or both parties aren't available. So the final 2-day hearing will be scheduled as the docket allows. Do the parties feel like a final trial management conference about 30 days prior to trial would be fruitful? We can ensure that the parties have filed final pre-marked exhibits and proposed orders and whatnot. Do you think that would be fruitful, Attorney Ames?
Yes, Your Honor.
Okay. What about you, Mr. Tanway?
Yes, Your Honor.
Okay. Okay, those will be the 2 next court events that the parties will have the notices sent to them. The 2-day final hearing and a final trial management conference about 30 days prior to trial. Encourage both parties to read the rules with regard to the court's expectations for the trial management conference. Okay. All right, so with regard to the review hearing portion of this hearing, each party will have about 10 minutes. Why don't I start with the petitioner first? So with regard to the review of the parenting and support matters, has there been any change in circumstances? Are the parties asking for anything different? Please go ahead.
Yes, Your Honor, we are asking that the court move forward with suspending parenting time in this case. Mr. Tanguay has not exercised any parenting time that was awarded to him, and my client continuously brings the children to the police department every Saturday morning in hopes that he will arrive and take the children, and he does not show up. It is becoming difficult for her to explain to the kids why this is happening, and so it would just be easier, since he is choosing not to exercise parenting time that has been awarded to him under the parenting case, that time be suspended and my client not be required to bring the kids on Saturday. And the other issue is making sure that the kids are picked up from school on Tuesday and Thursday. He was awarded parenting time with each one child each day. He is not exercising that time either. And so again, for her to be able to have a schedule, have assistance from family with childcare, we would request that it be suspended, and if Mr. Tanguay wishes to begin exercising it, he can certainly file a motion with the court, or he can send a written request to me and we can discuss what the terms would be. We're not seeking to take the kids away, but the Saturday mornings are difficult, Your Honor, particularly. They're not expecting him on the Tuesdays and Thursdays, but the Saturdays are really hard. With respect to child support, he did not pay any support until March of 2023. The division is involved. My understanding is Mr. Tanguay is disputing all aspects of the court's order, including the arrearage amount, including the amount going forward, including the payment. The division is working through that. So we're not seeking any changes on that, but an update for the court in terms of where that's at. Payments come in on 3 checks. She's gotten 3 checks in total, and they vary in amount, so it's not consistent. So that is the update on that. If the court would like me to get into my contempt motion, I'm happy to, but I understand that was if time was prevailing. Some of the issues overlap with the review hearing, but it's the pleasure of the court. We can schedule another hearing too.
We'll go back and forth on the review hearing issues and see what time we have.
Okay, sounds good, Your Honor.
Mr. Tanguay, with regard to review of residential responsibility, the schedule, and child support, tell me your thoughts.
Your Honor, may I approach the bench with, or give it to?
What is it?
This is the domestic violence stalking order. Do you have it?
I do.
Do you have it in front of you? I'd like to keep that and hand a copy to them and review and
Let
explain
me
why
see.
this is happening.
I
And
do have
appreciate
it right here.
Okay. May I present this to?
Why is that relevant right now?
Because she's telling me, saying, she's violating the orders, and I'm going to go through all the orders, if we can look at that. If you would like to look at the DV, I would encourage
Why
to
don't
give
you
this
sum
copy.
up why you think that's relevant to the review hearing, sir?
It's relevant to the review hearing because you just asked her. Here, let's go like this. The judges constantly ask me questions, but you didn't ask her any questions. You let her speak. I would like to present my defense uninterrupted, please.
Go ahead.
Okay, thank you. So if you look at the bottom left of every single, of the final order, you'll see a date that says NHJB 2001 DF 5/2/2022.
Yeah?
That is when they updated this. Now, if you look at these orders, go back a page. If you go to where the orders are, it says that I am prohibited from going within 300 feet of the plaintiff. Yet, she just said that she brings them to the police station, hoping that I'll show up there and do the exchange, which would be a direct violation of the domestic violence orders. And if you read 173B, the court is not only the court can change the order, and you have failed to change the order. I don't even know if you can change the order, and the other judicial referee has failed to change the order upon writing false and fictitious findings of fact, which are mathematically and physically impossible. Heidi Ames knows that they are mathematically and physically impossible, yet she continues to berate me. She has also written in emails saying that she will find me talking to her parents, which are right there, during an exchange, as a violation of the domestic violence protection order, which is not a violation of domestic violence protection order. That is the reason why I have not seen my children, because she can just say that I have caused abuse and I can be arrested without warrant, held in jail, and then I wonder how well this trial would go. I wonder how well this whole hearing would go. Everybody knows that 173B is unconstitutional. Now, if you also look at the court orders, which she recommended that we talk through My Family Wizard, which is a paid app, which is absolutely ridiculous, that would violate the protection order. I am not allowed to talk to Miss Ray at all because of a fictitious and false claim which she used to strategically get advantage in this hearing. She took 100% custody. Now, I got a call.
Say something, please.
No, thank you.
So, I got a call she has now enrolled my children into Robbie, my son, which I haven't seen since December 1st of 2022, into mental care because Kyle Russo, child is in counseling. He's in counseling because he's been ripped away from his father because of all this abuse. I cannot see my children under these stipulations with a false and fictitious domestic violence order. So, you asked me to discuss some of those reasons. So, I will violate the protection order if I go ahead and see my children at the police station, which is false, and then she's most likely still seeing her ex-boyfriend, and they have specifically made this so that they can control the situation and control access. I also would like to show the court a sent back letter that I mailed to Attorney Ames. And if I may present this to the judge, it is a sealed envelope.
When was it sent? What does it contain, and why was it
I don't
sent
remember
back?
what it contains a pleading service. It was sent on April 9th I believe, 2023. And you'll see, and then it has to go to Miss Ames. It's a sealed envelope. May I
And so
present?
I guess, how is it relevant to the parenting rights and responsibilities issues that we're talking about, sir?
Because she's lying. She's lying over and over and over again
About what in particular, sir?
about being in fear of me. I've never committed, there was no allegations of any physical or sexual abuse. She is using 173B to gain child support monies, and I have all that information here. It's a sealed envelope. It's addressed to Heidi Ames, exactly as in her template. It's been sent back, returned to sender, not deliverable, as addressed. She claimed domestic violence because I hand-delivered documents to her lawyer. It's in her hearing. It's in her paperwork. She's done it. Go ahead, lie.
Attorney
Lie to the
James,
court.
I'll get to you in a moment.
Thank
please.
you.
Lie to the court. Go ahead, it's being recorded. So this is here, this is for Heidi Ames. I wanted the court to document it, but I guess we can just do this. This goes
Can I
to
see it,
Miss
please?
Ames, yeah. There you go. You can open it and read it to the court at your own time, and I made copies. Further, I have 2 reports from the Bureau of Child Support Services, which I said documented her trying to get child support before even filing a parenting petition back in May of 2000, prior to filing, May of 2022. She filed in September of 2022. And then again, I'd like the court to note that she, on November 1st, prior to filing a domestic violence petition, she went to the state, they called her, and she said that she wanted to skip the orders for us to mediate, which the court knows this is a very difficult situation for all parties, for the children. We haven't even talked about the children. And she won't even meet with me. She won't even meet with me. She just sits there with her arms crossed, lies. She hasn't even spoken. This is the first time she tried to speak. So I'd like to give that to the court. I can give it to him there, but I can read it, whatever you want. I'd like to reserve the rest of my time to speak afterwards. I'd like to let Miss Ames speak. Or Miss Andre. Thank you. I do have other information, though.
I'll give each of the parties 5 minutes. Attorney Ames, any response?
Yes, Your Honor, I would put forth that if Mr. Tangway is so concerned about being within 300 feet of Miss, why is he here today? And the answer is, he's within 300 feet of her right now when it's convenient for him. The fact is, it's not a violation, and I've explained this to Mr. Tangway, that it is
that's
not.
objection speculation.
Sir, you've been given the opportunity to make your presentation without
Just
interruption
speculation.
or distraction. Sir, you saw how I politely asked, or not so politely asked Attorney Ames to have a seat
I apologize.
to allow you to continue. You will offer her the same courtesy. Attorney Ames, please go ahead.
Yes, Your Honor, through email, I advised Mr. Tangway that the domestic violence final order specifically says that parenting time will be addressed by the parenting case, because the domestic violence hearing, I believe, was December 13th. The parenting case was December 22nd. It was within 2 weeks, and so the court elected to have the parenting issues decided by this case. I explained to Mr. Tangway via email, if he thought there was a conflict between the 2 orders, that he was free to file a motion and send it to me, and I might even assent to it in order to make sure his concerns were met regarding a violation of either order. He has not done that. He has not done anything. And so with respect to him constantly saying that he is being denied his children, he is making the decision to not exercise awarded parenting time with the children. And again, I come back to, he's so concerned about a violation. This is in the Manchester Police Department. It's on camera. There are police around for the protection of both parties so that there will be no false allegations by anyone. There will be no attempts to communicate by anyone, and they can exchange the children in a safe in supervised manner. That is why we requested this, and he has refused. Again, Saturday after Saturday, these kids have gone to the Manchester Police Department.
To get stickers?
Hold on, Attorney Ames. Mr. Tangway, I think this is probably at least the third time that I've asked you not to interrupt these proceedings. Okay? I'm happy to have both parties be heard.
Lying.
And, sir, as you just interrupted me once again by muttering comments under your breath, I will tell you very clearly that such things are disrespectful and not allowed. I didn't allow Ms. Army to speak to interrupt your presentation, and you shall not do that to them, and you won't do it to the court either,
I apologize.
okay?
Very emotional.
Attorney Ames, anything
Yes.
else?
I just wanted to give the opportunity to my client to say something, Your Honor. I think this has been very frustrating
If
for
she
her.
feels the need and it's in the next 2 minutes, Ms. Gray, please go ahead.
I just kind of want to state my side about this whole DVP thing. Back in September, I even emailed Heidi asking if I should get one then, and she actually advised against it, saying how difficult it can make co-parenting. So I tried yet again to continue to work with him, but he did continue to enter my home without permission. After I told him not to, he would show up unannounced and all of this stuff. And again, that is the whole thing of like, it's really frustrating to me for him to keep saying that I am denying him from his kids. I have never done that. I've always wanted him to have this time with his kids, and he is the one that is causing them this pain.
Attorney Ames, anything else?
No, thank you, Your Honor.
Okay. All right, you have 5 minutes, Mr. Tangway. Anything else that you think the court needs to know at this point?
In direct response to Ms. Gray's statements, it's not true. There is a law called 633:4, interference with custody. On July 25th, 2022, Ms. Gray, before filing a parenting petition, hid the location documented for a month, removing my children from the state, and she snickers. Would you admonish her for snickering? No, the court doesn't. But anyways, she did it. That law was made in 2005 in conjunction with 461A, parental rights and responsibilities. We have rights and we have responsibilities. Okay, my rights have been violated, and I've documented that to the court. Right here is what I've been doing. This is why I haven't. This is, and she struck it. Her lawyer attempted to strike it and did get it stricken, but I can still appeal it. This is from the domestic violence petition at the Supreme Court. 480 pages I've had to write.
But go ahead, please.
Excellent, thank you, sir. So I also have from our daycare, which this is my account, and it says it's actually from November 30th, the day that she filed the false petition for domestic violence. It says, just wanted to let you guys know I am at court, so I may pick up Ethan a little late. Should be there by 5. Okay, no worries. Late pickup. Thank you. Just heads up, Bobby did text me like 15 minutes ago saying he was going to pick up. This is on December 1st, after the temporary protection orders were issued. She was not afraid of me and has never been afraid. She did it to disrupt this process, and has detrimented our children. Our children are hurting because of this. They're hurting.
Hey, why don't you go ahead and direct your allegations and your facts towards the court, please?
My children are hurting. I need to see my children. I love them.
Sir, the reason I just told you that is twofold, okay?
Mhm.
Number one, if you're seeking to have direct contact with Ms. Ray right here in the courtroom, that legitimately could be construed as a violation of the no
I'm not.
contact order. So I'm doing that for your own protection, sir. And also, I'm the one who's going to be addressing these issues, and I want to hear them directly from you, so please.
Thank you so much. So I have these, and I can put them in a more better format. It's, as you can see, this is immense. Your Honor, I want to look at you, and actually, I'm not lying. I've been nothing but truthful to this court. I love my children. My children love me. They, without warning, she has not even sent me anything, any contact, no birthday card, no Christmas card. She has not sent me any contact whatsoever. She could. She claims that she cares so much about the children, but she goes on vacations. She lied, and this will be addressed in the hearing. But what I'm saying right now is that we have to defeat, which I will win, and my appeal, because it isn't just, so that we can attempt to go to mediation. You could order mediation, because she could choose to go to mediation. She said, "Oh, he's not afraid, he'll come within 300 feet. I've asked the court and stated in the writing, we can come. The court rules allow us to come here, meet right in there, and go to mediation under the safety of this gentleman or whoever, and the mediator, and they can find out. I am not a violent person. A violent person does not write 480 pages. I'm doing this out of duress because I know that I've seen, and I've alerted you, Victor Luce get dragged in here, right here, handcuffed, because he went against a family with more money than him. And that's what happened. And I know Victor Luce. I didn't know him, that he was going to be there, but I know him. So I also have, here's this right here is how mediation is supposed to work. These are documents that you get at the beginning of every. Yes, sir. So mediation, we're supposed to go to mediation. And then there's a letter from Judge King, which I've also sent you. He's the administrative judge, senior judge, saying that you must go to mediation, think about your children. It's about her children. I don't even know if she's brought them to surgery. She has all decisions, and she did that, and she only has those decision-making capabilities because she filed a fictitious and false domestic violence petition against me to gain strategic control of this situation. And she has no evidence or claims of any physical or sexual abuse. There's no claims. And she has no evidence of those times that she says that I went to her house. I had a key for 6 months afterwards. We were supposed to figure out what to do, but she decided to date someone, a police officer, by the way, who was married at the time, 2 weeks after I moved out of the house. Is that in the best interest of the children? No, it's not in the best interest of the children. And then the narrative order that we've received was filled with holes.
You got about 30 seconds left, sir.
Yes, Your Honor. Your Honor, do you know how old my children are?
I do.
Without looking at that.
Well, 8.5 and 4.
That is incorrect, sir. Ethan's now 4. Robbie's about to turn 7 on May 11th. He has not seen me since since November 30th at all, because he was in the bathroom when I had to drop off Ethan.
Then that was probably poor math on my part. I apologize.
Yeah, and I understand this is a difficult situation. I want the court to work with me to make this right. And they can't be right with a false, fictitious domestic violence petition and the prejudice against a man. She kicked me out so she could get more closet space and go date other people. It's that simple. She was no longer attracted to
All
me.
right, sir. Thank you for your argument. Appreciate it. I will put it together in a review hearing order and a pretrial conference order that will go out to the parties in the mail.
Your Honor, may I briefly put on the record that if Mr. Tangway wants to know how the children are doing, I suggest he set up the Our Family Wizard account, because she regularly posts updates, including pictures of him when he lost his
Attorney
front
Ames?
teeth.
The parties can talk about that once they leave the courtroom, but I've got another hearing.
Understood, Your Honor.
If you please.
Let
Parties
it-
should always keep appropriate lines of communication open by mutual agreement. Thank you all. The hearing
Thank
is
you.
concluded.
Court to recess.
Thank you, Ron. Thank you.
Thank you.